we are proceeding with a hearing on Mr. Sneed, correct?
Yes, Your Honor.
Okay, we're going to attempt to do this on Zoom. All right, good morning, Mr. Stradley. Okay.
Good morning, Your Honor.
So, all right, we are going, and I see you, Mr. Sneed. So we're going on the record in the matter of Matthew Sneed, 23270. And appearance, counsel?
Good morning, Your Honor. Attorney Thomas Courts appearing on behalf of the defendant, Mr. Sneed.
Thank you. Mr. Sneed, your name for the record, please. Mr. Sneed, I'm going to need you to keep, okay, I need you to keep your volume. I need you to keep your camera on.
I'm having Wi-Fi problems. I'm at work. I think it's good now, though.
It's not. I see a black screen. Now I see you.
Yeah, this connection is my fault, Your Honor.
If there's going to continue to be technical difficulties, you're going to have to come in person. And then Ms. Halstead's present, and then Mr. Stradley's present. So, Mr. Sneed, can you please state your name for the record?
Matthew Sneed.
Your name for the record, please.
Matthew Sneed.
Okay.
Can you hear me?
Sir, I can, but there's some delay going on. Is there a difference? Okay, counsel, I'm not doing a hearing like this.
If you'd like us to appear in person, Your Honor, I could give minutes.
I'm sorry, what was that, Mr. Courts?
Your Honor, if the court would prefer, I could be there in 20 minutes.
Okay, Mr. Sneed is now off. So, any objection, Mr. Stradley, being on Zoom for the testimony, counsel?
No, Your Honor.
Okay, so Mr. Sneed?
Can you hear me now?
Okay, you and your attorney are going to have to appear
Today?
Yes, right now.
Right now?
Yes.
I stepped outside. It should be good now.
Sir, you and your attorney are going to have to appear in person. So
Okay,
we'll recall this matter in 20 minutes.
Thank you, Your Honor.
All right, thank you.
Can I get 30? I'm in Romulus.
Okay, you should be here in 20 minutes, sir. Right?
Okay. Yeah, I'll be there. 2025.
Will you hand me my spinning box?
Yes.
All right, I don't know what happens. We keep getting disconnected, but we're going to go on the record in the matter of the state of Michigan versus Paris Clegg, 231321. And appearance, counsel?
Good morning, Your Honor. Christopher Shemke, bearing me up my client's time to consent to the matter being heard via Zoom. As to the sentencing, we've had an opportunity to review the pre-sentence investigation. It's factually accurate.
Okay. All right. And Mr. Clegg, I feel like you were just here, but has it been a month already, or were you just here last week?
No, it's been a couple weeks.
Okay. I don't know. It seemed like it was just last week. I don't know. So, all right. And sir, you have a lot of warrants out for your arrest.
Yes, I'm currently taking care of it now. I'm on a work assignment through my job, well, through Segway. So they have me working at a gym right now, but I'm going through a case with my lawyer as well with them, so I'm just trying to figure it all out right now, but my lawyer is helping me take care of the warrants and stuff right now.
Okay. And you have a lawyer for what matter, sir? Other than this matter, you have a lawyer for what?
An injury I've sustained at work.
Oh, okay. Is that from a while ago or recent?
No, it was from April.
Okay. All right, and sir, I know that you stated that you, oh, I'm sorry, what's that?
I couldn't hear you. I'm sorry. I thought it was muted or something.
Oh, no. You indicated that you had one beer on the night of the offense, but I'm pretty certain, given your level, that you had more than one beer, right?
No, I had one beer.
One beer,
I'm certain. I know it was one beer. My wife knows it was one beer. And I drank it hours before I even took my kids to the park.
to where?
Can you hear me?
Before you took your kids to where?
To the park. It's a water park, like 5 or 10 minutes up the street from you all. I got pulled over directly across the street from the police station.
The water park, the one, the YMCA?
No, there's a little outside water park right down the street from you all.
Oh, do you mean the fountain?
It's like a little splash park for kids.
Oh, okay. Okay. But sir, so your level was still 0.11. And so I just want to make sure that we're all on the same page. And what's your wife's name?
I can't hear you.
What is your wife's name?
Swell a bell.
Okay. And sir, where do you believe all of your warrants are? You have the attorney that's helping you do that.
You said what?
Your warrants. What
Yes.
cities are your warrants in?
Dearborn, Inkster, Westland, one out of Detroit when I was 17. A bunch of old petty little traffic warrants that I may need to take care of, and some stuff that's already been taken care of. I just probably need to just show face again in court in order to get it removed from my record or whatever they're gonna do.
Make sure you're adding Allen Park to that list. You're adding Romulus to that list. Taylor, Southgate.
I know all of those things, ma'am. Again, I'm trying to take care of it. I have not been in the right spot in life, and I'm getting behind it now. Obviously, I'm working. I'm at work right now.
I understand that, sir. I just want to make sure that you are aware of all those, not just the ones that you stated the cities of. So here's the court going to order. I'm sorry, what's that?
I said, I'm aware, again, it's already being taken care of. So it won't be a problem. It won't be an issue.
Okay. All right, the court is going to order on your plea to an amended charge of operating visibly impaired and driving while license suspended. The court's going to state that after hearing from counsel, Mr. Clyde, reviewing the report, the recommendation that there is reasonable grounds to affirm MCL 769.5. 18 months probation, you are eligible for early discharge. And I'll go over that in just a little while. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately for any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. The court is going to also order you to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is to assist you in providing coping mechanisms so that you may maintain sobriety and prevent relapse, hopefully preventing this matter from happening again in the future. You'll have to participate in the MAD Victim Impact meeting. The rehabilitative goal for that condition is to further increase your understanding of the dangers of driving while under the influence and to educate you about the consequences of such behavior. The court's going to order 7 days of the court workforce. That's the rehabilitative goal for that condition is to help you further develop work and life skills and get back to the community. The court's going to also order you to obtain a valid driver's license, to attend a parenting class. The rehabilitative goal for that condition is to teach you further how to deal with daily responsibilities of maintaining a positive home environment and ensuring the children's health and safety.
Ma'am, I don't mean to cut you off, but my kids were taken from me, so I don't feel that I need any parenting classes. When I got pulled over that day, they took my truck and they took my kids. They mom not letting me see them. I have not seen my kids since August, and I told the judge there that I don't even want to be involved in it anymore. So I'm not even going to see them again anyway. I'm planning to move out of Michigan as soon as I clear up my warrants and clear my name. I broke up with my girlfriend, the one I was with at the time. So she lost her car. So again, I'm just really trying to clear up every mishap that I have in Michigan so that I can never come here again.
Okay, so I'm sorry, please back up. You stated that after this incident that the children's mother has not allowed you to see the children.
At all. I have not seen my daughter since April 24th, the day that I got pulled over. I mean, August.
Okay.
I have not seen them at all. Again, okay. I'm not put out with the court already.
Sir, please let me finish. Is there a court order that orders your parenting time to be suspended?
Yes. CPS. Child Protective Service. They came to my home, everything.
Okay. And so is there a pending case with CPS?
No, I have an open case for CPS, which they are telling me now that I'm not able to see them. I don't have any visits at all. So again, I'm not even going to deal with that anymore. I grew up without my father, and hopefully me working will be able to support them as much as she'll need. Because I won't do this going back and forth to court or jail about it. So that's just done. That's why I said I don't need a parenting class. I don't have any other children that I have a problem with. My oldest daughter lives in Ohio. I pay child support for all of my kids. I don't want to be a part of their life. I already discussed this with the magistrate judge down there. So I really don't feel that I need to do that. Anything else, I'll do just on the strength of, because I'm just trying to clear it up and get it done so I can leave. Honest to God.
So you don't want to be a part of your children's lives at all?
No.
All right, well, until I have something.
Not that I don't want to. Not that I don't want to. She's not allowing me to, and the state of Michigan is allowing her to do that. So where do I win that fight? Again, I grew up without my father. I'm pretty decent.
Sir, you have an attorney appointed to represent you down there, correct? For the CPS matter?
Yes, and he's not doing anything. Obviously, if I have not seen children, we just passed holidays, got more holidays coming up, birthdays, I just missed everything. So obviously he's not doing anything in order for me to see them again, and she won't let me see them. So I can't contact her, or that's going to be violation basically of me just asking her not to see my children. So I don't even want to deal with it again.
And sir, is that all as a result of this case here?
Yes. I broke up with the girl that I was with. She lost her car. I lost my kids and a bunch of other stuff in the long run. So again, I'm just trying to do what I have to do to initially leave the state of Michigan and start a brand new life. And I won't have to ever deal with it again.
And so you don't want to, so the CPS generally will put forth conditions by which certain things you have to follow, and then you would be able to be reunited with your children again. And
but again, it's always going to be a problem with their mother. So
Sir, you chose to have children with her, so that is what it is. And so because you don't like what she's, how she's, sir,
I'm the one in jail. I'm the one in jail for child support.
Please interrupt me. So because you don't want to deal with the mother of your children, you're going to just step out of their lives. That's what you're saying?
I'm already living another life. That's what she's mad about. I'm already We haven't been together for the last 5 years. My oldest daughter with her is 6. I have 2 daughters with her. We haven't been together since the first one was born.
You haven't been together since the first one was born, but yet you got another
I
child.
want to be the one continuously in trouble, having to pay child support, having to go to jail for child support, back child support, having to get arrested when she comes to my house and makes a fool of herself. All that type of stuff I can do without in my life because I don't need it. So that's simple. Like I said, I grew up without my father. I didn't turn out all out of whack. I'm okay. So again, the child support that they're asking, I hope that's enough for her to support the children because that's all I can do. I don't feel that I need to even go deeper into it because simply there's nothing that me, neither you or anyone else can do if it's been since August and I've been calling courts and I've been talking to the magistrates. I've been talking to different people down at the Penobscot building. No one's told me anything that I could possibly do to just get a 10-minute visit with my kids, even at a McDonald's, anything that would allow me to see my children, and no one's been able to help me at all. So again, I would rather not and know that I didn't. I'm not going to keep on continuously putting myself at fault. I'm a good man. I'm raising a child that's not even mine. I've been raising him for 5 years. He's been doing well. CPS came out to my home. They checked my home. They made sure everything was legit. So my case is probably initially going to get closed anyway, but I still don't want to deal with that after effect of what's going to happen with her. Just for me trying to see my kids and be there to be a part of their lives. So it's something I don't want to deal with, and it's going to drag me down for the rest of my life.
Well, the court is going to continue that condition unless I receive an order from the Third Circuit Court or CPS that suspends or terminates your parenting time. So I will amend that condition once I receive that documentation. The court's going to also order that you are to clear up your warrants and mandatory jail for any violation.
Mandatory jail for any violation.
So that means if somebody shows a positive on your drug test, or you don't appear for drug testing, or you pick up another case somewhere, or you're not clearing up your warrants, things like that, then that would be jail time. Any other questions, sir?
No.
All right, the court will note that this is as to that these conditions are concurrent. The court's going to order as to the apprehended or visibly impaired a $300 fine, $100 screening assessment fee, supervision oversight fee of $900. That's $50 a month at 18 months. And since you're eligible for early discharge, up to $450 of that may not be due. $200 for the cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50. Workforce of $280. And so that total is $1,905. And then as the driver license suspended, the court's going to order a $500 fine, cost of prosecution $100, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $725. Total between both is $2,630. And sir, did you post a bond?
Yes, I did.
Okay. All right. And so you can apply that bond, and then do you have any other money to pay today, sir?
No. No.
Okay. And so how much are you able to pay per month, and what days a month works best for you?
I'm gonna be all the way honest. The place where I'm living now, I'm on my last limbs, and I don't pay anything here. I work at a gym at the front desk. I'm barely making it.
And how many hours a week do you work, sir?
I can't hear you. I'm sorry, I couldn't hear you.
How many hours a week do you work?
20 to 40 hours. I'm working at a volunteer gym for veterans.
I understand that, sir. I understand that. I read your report. And so are you working anywhere else to?
No.
Okay. And your girlfriend works?
Yes, she works.
Okay. You
But
$20 a month, sir?
Do with what I'm doing. She's
What's that?
barely giving me somewhere to stay. So that has nothing to do with what I have going on.
So I was simply asking to see if you're responsible for 100% of the rent or part of the rent. I understand that she's not responsible for paying.
$600. $600 a month plus utilities, which is about probably 100 and something.
Okay. All right, can you do $20 a month, beginning next month?
Yes.
$20 a month, beginning January. I'll indicate January 12th for your first payment. And as I did indicate, sir, you are eligible for early discharge so long as all of the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you made a good faith effort toward making full payment. All right, so please email them to probation as soon as you disconnect here, and they will get you set up with an appointment to get your terms and conditions.
I need to do what?
You need to email them to probation so they can get you set up with your terms and conditions, sir.
Email my information?
You need to email into probation.
Email to probation?
Yes, so they can get you set up with your terms and conditions.
Okay. Can you let my attorney know so he able to text me or guide me on how to do it or whatever? Because
Okay. Mr. Shemke,
Yes, Your Honor.
would you mind please emailing or messaging Mr. Clegg with the email for probation, please?
Yes, Your Honor.
All right, thank you. All right, thank you. Good luck to you, Mr. Clegg. Have a good day. Okay, thank you. All right, we're going on the record in the matter of Matthew Sneed 23270. And counsel, your appearance, please.
Good morning, Your Honor. Attorney Thomas Courts appearing on behalf of the defendant who stands to my left. Please state your name for the record, please.
Matthew Sneed.
Okay. All right, and okay, Mr. Stradley, can you please state your name for the record?
Sorry, Your Honor, I was technical difficulties. Jeremy Stradley, EMS
Okay.
Tether.
Okay, thank you. All right, so here's what, so Mr. Sneed is on probation for operative visibly impaired. And he was sentenced April 27th, he had a probation violation hearing on November 6th. Whereby this court, where he pled guilty, this court sentenced him to 5 days jail, 30 days on the alcohol tether, mandatory additional jail for future violations, outpatient treatment, extend probation 3 months. Then it's alleged on the 13th, he failed to appear for drug testing and tested positive while on the tether. And then on the 27th, he pled guilty, but then we adjourned the sentencing for today's date so that Mr. Stradley could testify based upon what Mr. Sneed indicated the reason why he tested positive was. And so, Mr. Stradley, if you can please state and spell your first and last names for the record.
Jeremy Stradley, STRADLEY, EMS Tether.
All right, thank you. All right, Mr. Stradley and Mr. Sneed, please raise your right hands. Do you solemnly swear from the testimony about to give this man with the truth, the whole truth, and nothing but the truth, Mr. Sneed?
Yes, Your Honor.
Mr. Stradley?
Yes, Your Honor.
All right, thank you. Okay, and so, Mr. Quartz, if you're okay with that, I'm just going to kind of summarize for a moment. So Mr. Quartz or Mr. Sneed stated that the reason he tested positive for alcohol was because he received a haircut and a shave.
Aftershave lotion.
Or sorry, aftershave was alcohol, only alcohol, if I recall correctly, right? It was pure alcohol.
Yeah, so I do my research throughout this week.
Hold on, sir, hold on. Your testimony last week was that you had pure alcohol put on your face and your hair,
Yes.
your head.
Yes, Your Honor.
Okay. And so because of that, Mr. Sneed tested positive for alcohol on the tether. And refresh my recollection again, sir, your haircut was at 8 p.m.?
Yeah, you didn't get
Yes.
to 8:30, yes, Your Honor.
So your haircut started at what time?
8:30,
And when was your haircut complete?
about 9:15.
Okay. And so, Mr. Quartz, did you want to ask Mr. Stradley any questions?
If you allow, yes, Your Honor.
Yes, okay.
Sir, if I might ask, are you trained to identify what could cause this device to go off?
Yes, sir.
And do you believe that training has equipped you to determine all causes that would trigger this device?
That training is I'm sorry?
Oh, specifically, I guess I should ask, do you feel that your training and experience have equipped you to definitively answer the question if a large amount of aftershave on the face and hair on the head as well could trigger this device?
It could, yes.
That's all I have, Your Honor.
So your testimony, Mr. Stradley, is that pure alcohol on the face and the head of Mr. Sneed could give a positive result on the alcohol tether, on his ankle.
My apologies, Your Honor. The court misinterpreted, so did the attorney, and I misanswered. My response was yes, I can dictate the difference between the two. That's correct. However, in this instance, we have multiple peaks to a point, Your Honor. There's been multiple studies done as far as the absorption of alcohol through the skin. It's just to get to these levels in this kind of time is not a feasible thing, Your Honor. We have multiple individuals that are barbers, nurses, etc., that their hands are in contact with alcoholic substances all day long, to include bartenders, and we don't have these kind of issues.
Okay. So I think that was some clarification on that. The court asked a question based upon your question. And so, Mr. Quartz, do you have more questions now?
If I may, Your Honor.
Yes.
Sir, are you familiar with a Barton Morris?
I'm familiar with the firm, yes, sir.
Okay.
I'm
And
sorry, a what?
Barton Morris. I could spell it for the record.
Yes, please.
BARTON space MORRIS.
Is that a person or?
Yeah, it is a person that would normally testify in these matters. Unfortunately, my client can't afford that. And I don't know if now is the time to address a preliminary question, Your Honor, about this, or you want to proceed.
Okay, and so Barton Morris is a person.
Yes, Your Honor.
Okay.
Sir, are you aware that others may hold a contrary opinion relating to this issue?
I'm not aware of.
Counsel,
I'm aware of the data.
I'm sorry, Mr. Stradley. Counsel, I'm sorry, Mr. Stradley, just a moment. Counsel, I think that you need to be more specific. That's too general of a question.
Okay. What study specifically are you citing when you would say that this couldn't happen? Or is that your testimony that it's impossible or it's just not likely?
It's not likely.
But it is possible, correct?
In very trace amounts.
I'm sorry, very what?
In very trace amounts, Your Honor. The absorption of the alcohol transdermally through the skin, as it relates to getting to an elimination process, by the time the body would absorb that small amount, it would not be even traceable on the bracelet.
Sir, do you know today what study specifically you'd be citing and relying on?
I'm sorry?
Do you specifically, what scientific study are you relying on to draw your conclusion?
That was something I learned in the state of Indiana course by it's called the Borkenstein course for highway safety and alcohol control.
Okay. And what year was that, sir?
3 years ago, sir.
At this point, Your Honor, I don't have further questions for the witness. I do have a preliminary question about my client's ability to pay for his own expert, whenever the court would like me to address that.
Okay, Mr. Stradley? Your testimony was that this could be possible, a positive alcohol reading could be possible in trace amounts. Does that mean that the level would be a trace amount of level of alcohol indicating on the tether, or a trace amount that has been absorbed through the skin?
A trace amount that may convey to the tether, Your Honor. Again, the amounts that would be absorbed through the skin, and again, just an application to just your face momentarily is not going to get you to a 0.057 peak on our bracelet. Again, you know, as your body dissipates or eliminates that alcohol, it obviously deduces the amounts as well. So for that trace amount to be applied to somebody's face or head, to be absorbed through the skin transdermally, and then obviously showing up on our bracelet a little less than an hour later, is kind of irrelevant. I don't believe that's the case. In addition, there are 6 pieces of criteria. All 6 of those pieces of criteria must be met to be a confirmed alcohol consumption event. In this instance, all pieces of those criteria have been met. And as to the independent studies, there have been studies by NISTA. There have been multiple Dalbert and Fry hearings regarding the technology, Your Honor.
Okay, and what are those 6 pieces that you indicated were present?
So there must be a 0 alcohol reading on the bracelet prior to the event. There must be 3 peaks over a point, peaking out at over a 0.020%. It must meet the absorption and the elimination rates. The absorption rate not being greater than 0.10%. The elimination not greater than 0.035 on the elimination side. The 5th piece is it must return to a 0 alcohol reading. And lastly, it must pass the contamination test, whereas the device itself takes a sample from the environment, testing for alcohol or ethanol in the environment around the offender. If any one of those 6 pieces of criteria are not met or contaminated, the whole event as a whole, benefit of the doubt is given to the wearer and they throw it away.
Okay. And so, I know your testimony was a 0.057, but I'm showing the point as 0.075.
Somebody must have put that backwards, Your Honor. It's a 0.57, Your Honor.
Okay, I'm looking at the reading on the report, and it's over, the red lines are over the 0.075. Is that Mr. Sneed's test, or is his test the black mark?
Oh, Your Honor, my apologies. If you're looking at the graph, Your Honor, The red line is an
Yes.
indicator of the ambient temperature. The middle line, which is the blue line, that is the IR voltage readings. That tells us where the bracelet is fitting to be sure that there's not an obstruction. The bottom line, which is the black line, that is the indicator of the presence of alcohol, and in addition to the alcohol readings. Each one of those dots on the graph, that indicates the test. That device samples the wearer every 30 minutes.
Okay, so there's the clarification. So that would be a 0.057. Okay.
That, if you
And
look further
so-
down, the non-compliance, Your Honor, on page 4, number 2, it'll say peak TAC of 0.057 was established on Monday, November the 13th at 11:27 p.m.
It does say that. Okay, so in your, how long have you been in this profession, Mr.
9 years,
Stanley?
Your Honor. 9 years.
And in your 9 years of experience, have you had, and I understand that you have individuals that are barbers and bartenders and medical staff. Have those readings tested positive for alcohol consumption by using alcohol-based products?
What I can tell the court is in the past, generally when somebody's using an alcohol-based product and we get a reading on our bracelet, generally speaking, it's because they touched the alcohol product and touched the bracelet. However, that data looks completely different because the readings will go from a 0 alcohol reading to whatever that peak amount is. It doesn't continue to create more alcohol, Your Honor.
Okay. And it's your opinion that somebody having alcohol applied to their skin, on their face as aftershave, and their head would not generate a positive reading on the alcohol tether up to a 0.057. That was, it looks to be about maybe 2 hours after the event, maybe?
That's correct, Your Honor. The bracelet was at a 0 TAC reading at 9:24, which means that effectively about just before 10 o'clock, the first alcohol reading was taken. The first presence of alcohol was detected, I should say. So they're essentially that, yes, it had to meet all those pieces of criteria, Your Honor. Therefore, you have to stand behind the science. The science dictates that, this is a confirmed consumption event. We have to stand behind the science, Your Honor.
Okay. And when you outfitted Mr. Sneed with the tether, was he provided with instructions as to what items he should avoid?
Absolutely. Every enrollee is provided with a participation agreement. In addition to that participation agreement, they're also verbally spoken to. 3 things come out of the installer's mouth. 1 is nothing ever to get between the bracelet and the skin. 2, refrain from the use of products containing alcohol.
All right, any further questions from that, Mr. Quartz?
Your Honor, if I might, sir, would your testimony change if you heard 2 witnesses testify that they were with him the entire time that he wasn't drinking, and this occurred?
Sir, regrettably, the science speaks for itself and the data is the data.
On the subject of the data, what is your false positive rate on the test?
There is no false positive rate, sir. It's either positive presence of alcohol or no positive presence of alcohol. Hence the reason why there are 6 pieces of criteria, and all 6 of those pieces must be met. Any one of those are incorrect or not met, the event of the whole is thrown away. It's a pretty high standard, 6 pieces of criteria.
It seemed to be important to you to publish it and orally explain to your clients not to use alcohol-based products. I would assume that's because it has a tendency to create false positives.
It's not a false positive, it's the detection of alcohol. The only difference is whether it's a consumption or it's environmental.
Can you state today how much alcohol my client consumed that night based on this reading?
Well, hypothetically, if it's a 0.057, I would assume that would be like 3 or 4 beers.
Okay. And how long would 3 or 4 beers take to leave the system?
It's not what leaves, generally speaking, on this gram bracelet. It's anywhere between 45 minutes to 3 hours after the consumption is when we begin to detect it.
I'm sorry, is when you begin to detect it, is that what? your
That's
testimony
correct,
was?
Your Honor. So again, the bracelet itself is detecting the alcohol on basically the individual wearer's elimination phase. So as they are eliminating that alcohol, that's when we begin to detect the alcohol. Obviously, our peak is when they have finished eliminating and they start to stop eliminating. That's when our elimination phase begins.
So
Does that make sense?
this elimination, yeah. So this elimination phase, when you've seen the 0.057, does the elimination in the testing comport with the consumption of alcohol as it decreases in a normal human body?
As long as it meets the criteria of eliminating less than a 0.035%, that's correct.
At what time did that occur?
At what time did what occur, sir?
Did you see it meet your criteria of elimination?
Well, if we have a peak at 11:27 p.m. and then the bracelet's reporting that at 3:01 a.m. and the 0 THC was reestablished, then that would be the period there. It'd be 11:27 from the peak to the elimination when it stopped at 3:01 a.m., which gave us an elimination rate of a 0.016.
Okay. So was there testing between roughly 11 and 3, or are those just the testing periods?
As I stated before, there's the system itself takes a test every 30 minutes. As indicated, in each one of those dots represents that 30-minute window test.
So I guess what I'm trying to establish is, and if you know, every 30 minutes following the read of 0.075, was the alcohol in a body decreasing as you would expect it to from the consumption of alcohol up until 3 a.m.?
That's correct.
Would that also be true if it was an absorption through the skin?
What do you mean an absorption through the skin, sir?
Would the body eliminate alcohol at a different level if it was drank or absorbed through the skin?
That I'm not concerned. I don't know about that answer, sir. I can't answer that.
Okay.
I'm sorry, can you ask that question again, counsel?
Yes, Your Honor. Alcohol could be consumed in 2 ways, maybe more, but you could drink it or you could absorb it through your skin. My client's alleging that it was absorbed through his skin. It's my understanding your testimony is you don't have a way to differentiate the elimination rate on your device between consuming it and drinking or it being eliminated if it was brought into the body through the flesh.
Well, that's not completely true, actually. If it's in the body and it's being eliminated, it's going to be the same rate, regardless of how it got there.
That's all the questions I have.
Okay,
Say something, Your Honor?
just a moment. And so, Mr. Stradley, as to the Tether reading, there's zero doubt that there was alcohol detected on the Tether and in Mr. Sneed's body and absorbing. The testimony is you cannot state as to how that alcohol got in there. Is that what I heard your testimony?
Yes, Your Honor. I says what I can state is that the data supports a confirmed consumption event. How the alcohol got into the individual's body, I cannot tell you how that happened. However, we can tell you that this is a confirmed consumption event based on the data and the criteria.
Okay. And in your experience, the rapid increase at 8 p.m. until it appears to be approximately, what is that, 11 p.m., 10 p.m.?
So if you look at the bottom of page 4, Your Honor, The bracelet didn't actually begin detecting alcohol until approximately just before 10 p.m. that evening.
Okay,
And then approximately
And then
an hour and a half. Go ahead. I'm sorry, Your Honor.
I'm sorry, then 11:30 PM is when the peak of 0.057 had been reached, correct?
That's when that was established. That's correct, Your Honor.
And given your experience with individuals that have either had absorption on their skin or consumption, in your experience, would absorption give that rapid of a rise on that rate? If it was merely absorbed on the skin as opposed to consumed?
Your Honor, we can't ascertain exactly how the alcohol got into the individual. What we can say is that there was alcohol in that individual's system. All that data supports and meets the criteria for a consumption event. Obviously, as the court knows, there's multiple ways to ingest alcohol, not just orally. So again, I don't know what transpired that evening, but whatever data that we have and collected off of Mr. Sneed that night supports a drinking event, Your Honor.
All right, thank you. Okay. Any other questions?
No, Your Honor, thank you.
Okay, and so Mr. Stradley, can I have you stick around for a few minutes just in case I need some additional testimony from you?
Absolutely, Your Honor.
All right, thank you. All right, and counsel, it sounds as though your attorney or your client wanted to say something.
Yes, Your Honor. And first, I just want to say we really respect the court taking the time to do this, and I know that is a big ask. If the court thinks it would be helpful, I just want to make the court aware we attempted to obtain an expert. I believe I only retained him roughly 7 days ago. He interviewed with an expert that he believes will testify that this is possible. This is a possible scenario. The problem is he needed $2,500. My client can't afford it yet. If the court was willing in 30 days, my client can afford it. If he wanted to take the testimony, carry over, and he thought that would be helpful, I just wanted to make the court aware of that option, that there is an expert out there. It's my understanding that will come in and explain detail by detail how the absorption through the skin due to this process is possible.
And who is this person?
That is BARTON space MORRIS. And I believe he is well known. It seemed that the government's expert was aware of him as well.
And what would the relevance of that testimony be, counsel? Because at the end of the day, your client is pled guilty because he had alcohol in his system.
100%, Your Honor, and that was his mistake. But I think there's a huge difference in making a mistake. Many men get shaved with alcohol. I've done it. Almost every man has. Sometimes there's no alcohol. Sometimes there are. Haircuts and shaves are very relaxing. You're not thinking about it. You still, understandably, should follow the court order. But the intention is hugely different than that and drinking, and it may influence the court's willingness to punish more severely. And in this case, not only is there a text message showing that a barber was coming, a letter from a barber, so it's not like somebody just made this up in advance to come here. There's two witnesses to say, I seen him get the haircut, but not only that, I fell asleep next to him, and the other guy works with him, and we drove to work together. No drinking occurring. So this is very good evidence to suggest that this may be an accidental thing, and I believe that the punishment should be much more severe if he drank beer than if he accidentally absorbed. And if the court felt that way, Mr. Morris's testimony may be able to convince the court that that's possible.
Okay, so where's the barber? Because I'm going to tell you right now, that's who I want to hear from. Where's the barber? Because that would be less expensive than the expert.
He teaches a class. I tried getting him in today, but he was teaching a class from 7:45 to 3 p.m. If you can set it up
Every Monday?
Yeah, every Monday, on top of traveling while he cuts hair. That's how he makes his money.
And what class does he teach?
I don't know what type of class. I have text proving that he's in class, if you want me to show you, Your Honor. He said he had class. I did ask for him to be here today.
He's in class or he's teaching a class?
He's teaching a class.
So counsel, you don't want to subpoena him?
Your Honor, and that is a trial shift. I usually don't because the other two witnesses and my client could testify that he was here and he provided the letter. The only reason I don't do that, Your Honor, is because sometimes when I subpoena witnesses against their will, especially when it disrupts their job, they come in and they are aggressively negative. If the court would be willing to adjourn maybe one day for the barber to come in, if that'd be helpful to the court, we do believe he's willing to testify based on his letter.
Yeah.
Well, all right, well, let me also just say this, right? I mean, the witness may come in aggressive, but at the end of the day, the truth's the truth, right? Whether it's aggressively testified to or not.
In my experience, sometimes the truth changes based on people's disposition, Your Honor, but I understand the court's point.
Fine, you'll come back on the 6th, on Wednesday.
Thank you very much.
Thank you, Your Honor.
At 8:30.
In the morning?
Yes, I'm not going to be here at 8:30 at night.
I just had to ask, Your Honor.
I can tell you that. And if the barber's not here, I don't know what to tell you. I'm not adjourning it again. Because quite honestly, I don't know what Mr. Morris will testify to other than, yes, the skin would absorb the alcohol, right? And I think that that's been already made clear. The skin can absorb the alcohol. At the end of the day, alcohol was detected on the tether on Mr. Sneed. However it got there, it got there. I don't know that Mr. Morris's testimony would be necessary. I want to hear from the barber.
I'll get him here for you, Your Honor.
8:30 a.m. on Wednesday morning.
Thank you, Your Honor. See you Wednesday.
All right. In person. We're back in person.
Okay.
In person.
Yes.
Same with the barber. In
Okay.
person.
All right. Thank you, Your Honor.
Thank you.
Your Honor, will you need me present at that hearing?
Mr. Quartz, are you going to need, would you like to have Mr. Stradley present
No,
again?
no, ma'am.
Okay. All right, then no. Thank you.
Thank you, Your Honor.
All right, we are going on the record in the matter of the City of Wyandotte versus Autumn Bulchak, 2324779, 23739, 23405.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom. As to the arraignment, we waive formal reading. My client stands mute.
All right, and Ms. Bulchak,
Yes, Your Honor.
your name please for the record.
Autumn Bulchak.
All right, and so counsel, let's handle the most current matter because the other two matters are probation violations. So, as to the current allegations, you indicated your client was going to waive the formal reading. Is that what you indicated?
Yes, Your Honor. I've gone over the charges as well as the violations. We are prepared to move forward. No formal reading required on either proceeding.
All right, and the court will waive the formal reading, enter plea of not guilty for purposes of the arraignment, schedule this matter for a pre-trial on December 19th at 9 a.m. And as to the probation violation counsel, would you like to set these for the same time? Same date and time?
Yes, Your Honor. Yes.
All right, the court's going to enter pleas of not guilty on these violation hearings. And set these for December 19th at 9 a.m. And just for the record, these are on case number 23405. It's alleged that she failed to appear for probation visit On June 15th, failed to register and begin drug testing as ordered, failed to comply with any conditions of probation. And then also on the 23739, failed to appear for any probation instructional on June 15th and June 22nd. Okay, and counsel, as to bond.
Your Honor, we respectfully request any consideration towards leniency. My client's apologetic for not being in full compliance. She's 26 years old. She's responsible for a 3-year-old girl. She lives in Wyandotte. She indicates she will appear at any and all future court dates. She's deeply apologetic for not complying with terms and conditions, and obviously it's our hope to potentially find a resolution at the next court date and potentially have some probationary terms run concurrent with her new case. But she is hopeful to be in full compliance, and she indicates that she would be very interested in seeking some treatment going forward. Thank you, Judge.
Okay, ma'am. You're telling this court that you have custody of your child?
No, I do not.
I'm sorry, what's that?
He does not have custody. Currently, the child is with the father, but she would like to regain being an active parent. But no, she does not have custody of the child as present.
Okay, so how often do you see the child?
I haven't seen her.
And how long?
Almost a year.
Okay, but you told your attorney that you're responsible for your daughter, correct?
To the extent, Judge, that she would like to be responsible. So I'm sorry if that's a mischaracterization. She would absolutely like to be reunited and again take on the responsibilities of being an active parent, Judge. But no, she did not mislead.
Okay.
I don't think I'm qualified yet to be an active parent, but I did say that I do have a biological daughter that is she'll be 4 in January. That I did say.
Okay, ma'am. Well, what would be in your system if you were tested today?
What?
Yeah. What would be in your system if you were tested right now?
Nothing.
Nothing.
No.
Ma'am, you were sentenced on your other matters on April 5th on the 405 matter. And then on May 30th on your 739 matter.
Correct.
And ma'am, you're saying that you want treatment?
Yes.
Okay, you were in treatment just 6 months ago.
Yes.
Okay, and so how long ago did you relapse, ma'am?
Probably a few months ago.
Okay, so what I'm going to order is on 232479, based upon your failure to appear on your other matters in this court, your failure to do anything as it relates to probation, failed to register for drug testing, failed to even appear for your probation visits, failed to comply with any terms of condition, and the fact that you're on probation for 2 matters that are similar in nature to these matters, the court's going to order a $7,500 10% bond. In the event you post bond, ma'am, GPS tether to the Wayne County Jail. And in the event you request treatment while you're at Wayne County, you may be tethered to treatment.
So I can bond out. So if I place bonds or post bond, then I'll get a GPS tether.
To treatment, yes, to treatment.
And what happens if I don't post bond?
You'll be in the Wayne County Jail.
For how long?
Well, at least until your next court date on December 19th.
and where's the
And then
treatment center to?
I'm sorry?
Where did it say that I have to be placed to treatment at?
And if you are in custody and you are at the Wayne County Jail and you are requesting treatment, then I've made a note in there that then they can tether you to the treatment facility.
That they can tell me a treatment facility?
They can tether you to treatment facility.
Right, I'm just wondering which place it was.
I don't know, ma'am. There is a variety of them that they utilize. I don't know.
So I'm going to jail?
Yes, ma'am, you're going to jail. And on 23405, $5,000, 10% bond.
How much is that?
$500.
And 7,500 for the other one?
Yes. And then just while you're doing your math on 23739, it's going to be another $500 because this court's going to order another $5,000, 10% bond on that one as well. And GPS tether, you got to post bond. And again, you're not to possess or consume any alcohol or drugs unless prescribed.
Ma'am, there's no way I can get out of jail today?
Absolutely not, ma'am. You have not even contacted the court here many times over the last number of months. Nope, not at all. And then now you're back in custody for the exact same thing you're on probation for, so no way.
Ma'am, I'll never do drugs again. I'll never bring them to Wyandotte again. I just want to be back in my baby's life. I just want to be with my baby father. I just want.
Ma'am, right now you're not in any condition of being your child's life, and you even acknowledge that. So not happening.
I don't want to go back into the system. I don't think that it's right for me. It's not. Last time I was in there.
So when you're at the Wayne County Jail, you can request to be sent to treatment. And I've made a condition that you can be tethered to treatment upon your request.
So as soon as I get there, I can request to go to treatment?
That's what you're saying? I'm not sure how that works. I don't know at what point you can ask for that, but yes, upon your arrival, go right ahead.
And I'll have to wait until my December 19th court date?
To appear back in this court, yes.
Okay, how many days, Your Honor, are you saying that I have to spend in Wayne County?
Well, ma'am, today is the 4th, and the next date you'll be here is the 19th. So that's 15 days.
And do I have the opportunity to, so the only way I can get out is if I post bond?
Ma'am, let me be very clear. If you post bond, you're going to have a GPS tether, and then you are going to be tethered to treatment. So anywhere you place it, you're tethered to treatment, not back to your home.
Right. So I'd rather just wait it out?
I can't tell you what to do, ma'am. I can't tell you what to do.
Thank you, Judge.
Thank you. All right, thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. The day is a joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Ms. Reed, we're gonna start bringing people in. People to learn how to act in a courtroom.
Can you hear it? Can you hear it? Man,
Matt,
can you hear me?
No, I know.
Okay.
I have no patience for that. But trust me, out of the day, I'm sitting up here, I'm the one that needs